The one by Warner. Bush's bill was yesterday. Yeah, I read it. I don't know if the Warner candidate out yet today. Maybe so. They're immediately I have some idea what the other bill will say.
Can I sign and put one on your desk? Okay. I'm glad to sign a perpetual one. Do you know if there's a bottle of water anywhere? Well, I just found it. Well,
That's great.
If necessary, I'll use this. Don't worry about it.
good to see you.
Have you seen the Bush bill?
Yes,
Is it unbelievable?
it's horrible.
It's basically signed off on
Yeah, it's better than, I think the Bush bill is better than the executive order was. So it has all of these other things that Scott and I were talking about, like changing the definition of torture, making the Detainee Treatment Act retroactive.
Yeah, it models itself on the code, creating a new section under Title 10, but contains those glaring omissions, which, in my view, still keep it from satisfying Article 75 of Additional Protocol 1.
Hello. I want to thank you all for coming to the American Constitution Society's first event of the year, Reexamining the Balance of Power Through Guantanamo Bay, a discussion of Hamdan v. Rumsfeld. So excited that we got such a big turnout. I also want to thank Professor Schrader and the program in public law for providing lunch for all of us. And if you're interested in learning more about the American Constitution Society, please come up and talk to me at the end. My name is Lily North. To begin with, I want to introduce our faculty speakers. Each of the speakers is going to present for about 12 minutes, and then there will be time at the end for questions. Professor Siliman, who will speak first, has 25 years of service as an Air Force judge advocate and is a nationally recognized speaker and frequent commentator on CNN and NPR concerning issues of military law, law of war, and international human rights. Here at Duke, Professor Siliman is the executive director of the Center on Law, Ethics, and National Security. And this summer, Professor Siliman was privileged to testify about military commissions in the light of Hamdan v. Rumsfeld in front of both the Senate Committee on Armed Services and the Senate Judiciary Committee. Professor Morris, who will speak second, is deeply involved in national and international human rights issues. She has served as advisor to the Chief Defense Counsel of the detainees at Guantanamo, the senior legal counsel to the Office of the Prosecutor for the Special Court for Sierra Leone, and co-convener of the Inter-African Cooperation on Truth and Justice. Professor Morris has advised the likes of the President of Rwanda, Secretary of the U.S. Army, and the U.S. Naval Justice School. And here at Duke Law, Professor Morris leads the Guantanamo Defense Clinic. And last, but certainly not least, Professor Chemerinsky is a nationally recognized constitutional law scholar and attorney. He's the author of many books, many law review articles, and he has earned too many awards for me to name them all. Professor Chemerinsky also frequently argues cases before the Supreme Court, including Van Orden v. Perry, a challenge to a Texas Ten Commandments monument, and Scheidler v. National Organization for Women, a case about stopping violent protests of reproductive health clinics. Hamdan v. Rumsfeld is a profoundly important case that stands for continuing a rule of law in the midst of very serious national security issues. I know that our distinguished guests will provide us with a fabulous and nuanced understanding of the case, but I wanted to share a very, very brief summary of the case in the form of a quote. One of Mr. Hamdan's attorneys, Neil Cattell, was a recent guest on the Comedy Central show, The Colbert Report. And in Mr. Cattell's interview with Stephen Colbert, Mr. Cattell summarized the case by saying, Hamdan is going to get a fair trial, and that's the happy ending. So without more to do, Professor Siliman.
Thank you, Lily. That doesn't work, so we'll just work from the podium. Let me try to frame the case as far as what the facts were and what the holding was, in my opinion, and then that will hopefully set it up for our discussion. Hamdan was Osama bin Laden's driver, his bodyguard. He was picked up on the battlefield, taken to Guantanamo Bay. And he was one of those that was selected by the President of the United States under the President's military order of November 13th of 2001 to be prosecuted by a military commission, as then constituted by the President. As Lily mentioned, Neil Katyal and Lieutenant Commander Charlie Swift of the Commission Defense Lawyers frontally challenged that in federal court. And it was determined that in the district court level, that the President had overstepped his authority when he made the determination that the Geneva Convention did not apply to anyone that had been captured, either al-Qaeda or members of the Taliban. And he did that on the 7th of February of 2002. So Robertson ruled at the district court level that the commissions could not go forward because Hamdan and presumably others were presumed to be prisoners of war under the Geneva Convention, and if they are presumed to be prisoners of war and not proven otherwise, then they can only be prosecuted by a military court-martial under the Uniform Code of Military Justice, a very different system with inherently higher due process standards than the President's military commission system. That opinion of Judge Robertson was reversed in the Court of Appeals for the District of Columbia, and the Supreme Court granted cert in this case. And what's interesting is that after the granting of cert in the Supreme Court, the Congress on the 30th of December of last year passed the Detainee Treatment Act, which most of us are familiar with as far as John McCain's amendment, which prohibits cruel, inhuman, and degrading treatment. But another part of that act, and I'm sure Professor Chemerinsky will spend more time on this, stripped the courts of jurisdiction to hear this type of case, and the government moved in the Supreme Court that it no longer had jurisdiction over Hamdan's case. Of course, as we know, on the 29th of June, the Supreme Court held that the Detainee Treatment Act was not retroactive, that it was prospective only, that it could hear this case. And on the merits, it ruled not on a constitutional issue, but on a statutory interpretation. And what is interesting is that the court, in my view, acknowledged the President's authority under the Constitution as Commander-in-Chief to create these commissions. It did not discount that. But what it said was plainly this, that when the President, acting in that role as Commander-in-Chief, does create these commissions, that he is necessarily limited to any congressional constraints that may have been passed. In that regard, it's what I call a Little versus Bream case. Students who have taken national security law or other courses are familiar with John Marshall's opinion in that case, where he said that when Congress legislates in that area, the President must stay within it. So what the Supreme Court said in Hamdan was simply this, that the President ran afoul of the restrictions that Congress had imposed in two provisions of the Uniform Code of Military Justice. The first one it mentioned was Article 36 of the Uniform Code of Military Justice, which basically says that when you have military commissions, that insofar as practicable, the procedures used should be uniform with the same rules for courts-martial. And the court said the President did not make a case for deviating. He clearly made a case for deviating from rules in federal district court, but not from courts-martial. So that was one of the two limitations that the court cited. The other was another article of the Uniform Code of Military Justice called Article 21. And that establishes concurrent jurisdiction in military commissions and courts-martial over violations of the law of war. And what the court said was, when it read the phrase law of war in the Uniform Code of Military Justice, that phrase law of war necessarily includes, at the least, Common Article 3 of the Geneva Convention. Common Article 3, dealing with non-international conflict, sets a minimal level of humane treatment, regardless of whether you're a lawful combatant or an unlawful combatant, regardless of what type of conflict it's in. It prohibits the taking of hostages. It prohibits torture. It also prohibits cruel, inhuman, and degrading treatment, including offenses against personal dignity. And fourthly, it says that if an individual is to be prosecuted, then it must be by a regularly constituted court that affords judicial guarantees recognized by the civilized people of the world. And the court looked and it said this fourth provision about a regularly constituted court affording judicial guarantees, this military commission system does not meet that test. So Article 34 and Article 21, 36 and Article 21 were the two statutory limitations that the court looked at to say that the president's program did not meet those provisions. Now, I am in probably the very great minority in reading the Supreme Court's opinion as saying that Common Article 3, that level of humane treatment, applies to military commissions as established by the President of the United States. I do not think the court intended in the Hamdan decision to extend the application of Common Article 3 to other applications of presidential power in the war on terrorism, including the CIA, secret sites, etc. Now, I'm not saying the court said it did not apply. I'm only saying that I think that was an issue for another day. That was not a part of the facts before the court. But I'm sure if you've read the newspapers, there are a lot of individuals, very learned, who have suggested that that's exactly what the court said. Now, my point would be, if that were true, then why are we debating what the CIA could do? Because if the Supreme Court said that the CIA was bound by Common Article 3, then we wouldn't have the debate that we're still having. That's what the court said. It stopped military commissions, even though none had yet been held. And it then tossed, particularly through an invitation by Judge Breyer, an invitation for the administration to work with Congress. And I think most of you at least heard about or maybe watched the President's speech of yesterday, when the President of the United States argued very forcefully in defending the, I think he said, alternate tactics used by the CIA, that these yielded protection for you and me and citizens of this country and, in fact, saved lives. He also said that he was transferring, actually had transferred, 14 of what they call the high-value detainees, including Zabeta, KSM, and others, to Guantanamo Bay, where presumably they are, and said now they should meet the bar of justice. But the problem is that under one's normal interpretation of international law and the Supreme Court's decision, the type of information that was undoubtedly gathered from these individuals at those sites, at the very least, was probably procured by coercion. So that brings the issue to the fore. What type of military commission system must be put in place by Congress to allow these people to be prosecuted? There are two, at most, 4 versions being offered in the Senate. The President's bill will be offered, has been offered as of yesterday. Senators Graham, McCain, and Warner are working on a piece of legislation that would hew more to the fairer standards of the Uniform Code of Military Justice, but make exceptions for things like not requiring a Miranda-type warning for terrorists on the battlefield. There are other versions, one submitted by the National Institute of Military Justice that that basically tries to stay to the code, and several others out there. I'd only suggest that this is going to be a very significant debate, laden with politics, simply because the administration now has 18 days left in this Congress to push this through. And my reading of some of the senators who I've mentioned, McCain, Lindsey Graham, and Warner, is that these gentlemen are more concerned with how we appear to the rest of the world than just bowing to a provision and creating a system that will guarantee 100% conviction rate. I think that's very important. There are other parts of the bill that are kind of worrisome. It also contains, although it's not related to military commissions, an amendment to the War Crimes Act whereby it basically says that we are interpreting acts of cruel, inhuman, and degrading treatment as basically acts of torture, and nothing less will suffice. And the other thing that is at least worrisome to me personally is making the Detainee Treatment Act and all its provisions retroactive, which is, in effect, legislatively overruling what the Supreme Court decided on the 29th of June. These are issues I wish I had the answers for you. I would only suggest that what will happen in the next several weeks in the Congress is absolutely vitally important to how, one, trials of terrorists will and should be conducted, and I think more importantly, how the United States, as we claim ourselves to be a nation under the rule of law, is viewed by the rest of the international community. If we set a bar for ourselves that is lower than what international law requires, and which we expect of other nations, then I think we serve ourselves poorly.
Hi there. As Professor Siliman has said, there was the White House bill that came out yesterday in response to the Hamdan decision's invitation for the president to work with and through Congress in order to remedy some of the defects that the Supreme Court found with the military commission process as it was run in what I'll call the first round. The administration's bill, I think, is almost surely dead on arrival, at least in its current form, because of the Warner-Graham-McCain bill that Professor Siliman also mentioned. Those senators occupy very important seats on the relevant Senate committees, the Senate Armed Services Committee and Judiciary Committee, and are in their individual capacities particularly prominent and influential voices in particularly the areas in question. So while the administration bill has many other problems and certainly has its detractors out there, the arrival of this new rival bill is going to be particularly significant, I think, in defeating or so dramatically toning down the White House bill that, in terms of what ultimately would be legislated, that it would be eviscerated in terms of what the administration now wants. I believe that that will be true. Don't know it. There was also a bill, by the way, that was produced here at Duke in conjunction with the Office of the Chief Defense Counsel for the commissions, which was beginning its process of presentation at the Senate, and which I think, although we haven't decided within OCDC, the Office of the Chief Defense Counsel, yet, probably, and this is just my speculation and my thinking on it, probably should now be retracted for reasons including, well, the main reason being that it would probably be better politically to get behind that very powerful bill that's now come out by Warner-Graham-McCain, perhaps seeking to influence some adjustments to it, but rather than to attempt to run a different bill that will be essentially similar. The WGM bill is certainly a fairly close look-alike to what was submitted about a week ago for consideration from Duke. So that said, what are the implications of Hamdan and what is its effect now in the legislation that we're seeing coming out of the administration in particular. First, of course, we're going to assume a war model. As we all know, the various attacks in the last few years have been responded to both as war, the war on terror, and as criminal offenses. Certainly we've had criminal trials in federal courts about the crimes involved. But today, and for relevant purposes, for military commissions, we're talking about the law within the war model for looking at these events. Within law of war, it's quite permissible to hold individuals from the enemy side who are captured in the course of the armed conflict. You capture them, you can detain them until the end of hostilities without any basis in criminal law, without any accusation of criminal conduct, rather just because they're captured, the war is still going on, they're enemy combatants, and it makes sense to hold them rather than to let them go out to the battlefield. And from a very practical point of view, that's not what would happen. Captives would end up being killed rather than released. So under law of war, the idea of detaining enemy combatants till the end of hostilities is uncontroversial. That, however, only describes and is the basis for the debate about those hundreds of individuals detained at Guantanamo, but who are not being prosecuted for any crimes. There's a mere handful of individuals who it is said will be brought before military commissions, who have been identified as the individuals who will be brought before military commissions for prosecution for war crimes. What I want to talk about in particular is some of the issues that have arisen in the application of the law of war in the more controversial, on the more controversial questions as those apply to specifically those being prosecuted in military commissions. So leaving aside the other detainees and the uncontroversial issue of detention in law of war, though I should caveat, the issue of when this war would end and how we would know is highly problematic. But leaving that aside and going to the those who are accused in criminal terms and to come before military commissions, as you know, one of the big issues has been whether the individuals to be tried have the status of prisoners of war under the Geneva Conventions, or whether instead they're what the administration has called enemy combatants, an odd name for it because prisoners of war also are enemy combatants. But what also are called, and what I will call unprivileged belligerents, whether they're privileged and enjoy the rights and privileges of POWs, or instead don't qualify as POWs under the conventions and therefore are unprivileged combatants. The Geneva Conventions certainly do contemplate that there could be combatants, people fighting in an armed conflict, who are not entitled to prisoner of war status if they're captured. And there are certain conditions laid out in the Third Geneva Convention on prisoners of war for who qualifies and therefore gets the privileges, and what combatants don't qualify and therefore don't get the privileges. It's odd what the administration has done with that. The Geneva Conventions lay out three categories in the convention's definition of who's a prisoner of war. Those who are members of the regular armed forces of a state, if captured, are prisoners of war, period. That's what it says. Second, irregular forces, militias, those who are not attached to or form part of the regular armed forces of a state, but are engaging in combat, if they're captured, then they have to have complied with 4 conditions in order for them to be considered prisoners of war. And thirdly, the Geneva Conventions specify that the regular armed forces of a state, that is, going back to, I don't know why it's broken up in this way, but going back to the first category, the regular armed forces of a state, that they will be POWs even if the government of that state at the time of the hostilities is not recognized by the capturing party. The administration in the first round of debates about Guantanamo maintained that none of the captives were prisoners of war because, the administration said, none of them complied with the 4 conditions laid out for irregular forces, that is to say, for non-state forces to have to comply with to be POWs. But the Taliban army was the armed force of the then government of Afghanistan, albeit not a government not recognized by the United States. Geneva Convention specifically says it doesn't matter whether it's a recognized government. Instead, the administration took the position, contrary to the text of the convention, and with a rationale that is not strong at all, but which I guess I won't go into right now, took the position that even though the category states armed forces are automatically POWs under the convention, that somehow for a lightweight reason, nevertheless, what it really meant was that they had to comply with the 4 conditions. Since they had to comply with the 4 conditions, Taliban wasn't entitled to be considered a POW automatically, and indeed was not to be considered, were not to be considered POWs at all, notwithstanding another provision in the Geneva Convention. This provision being the one that says, in cases of doubt of whether somebody's a POW, they get an impartial tribunal to decide the question. The administration said that's in cases of doubt. We have no doubt, no tribunal. And thus has treated Taliban and Al-Qaeda or any other denomination of irregular forces as non-POWs and not accorded the particular rights that are accorded to POWs. That and many other controversies was not decided, that issue was not decided by the Supreme Court in Hamdan. Didn't get that far. And I'll come back to why it didn't get to these various questions, POWs and other ones I'll mention, because it didn't need to. It sort of was able to decide the case, as it always likes to, on narrower grounds. What the new administration bill does on this issue is to reiterate verbatim the relevant Geneva Convention's provisions, including the one that says state forces are POWs captured, including the one that says that's so regardless of the recognition of the government of the state in question, lays all that out, and then says neither Taliban nor Al-Qaeda nor certain other categories will be POWs if captured because they don't comply with the conditions under the Geneva Conventions. So what the administration appears to be doing here is to have a congressional determination, a congressional act that would codify the administration's earlier interpretation saying that Taliban and others are not POWs if captured. The alternative explanation, the alternative motive of the administration, which might become an argument that we'll ultimately see being made in a court, would be that no, if that portion of the bill is indeed adopted and Congress has thereby said that Taliban forces are not POWs if captured, then Congress has chosen not to comply with the Geneva Conventions. Congress can do that. It will be later in time after the treaty was entered into, and that therefore that's the law for the United States because Congress so stated. Unlikely that that interpretation would be accepted for a variety of reasons, going to doctrine about interpretations of cases concerning treaties and so on. But that's an issue where Congress, where the administration is asking Congress to make a particular determination, a particular interpretation of the Geneva Conventions, which I think will ultimately end up back in court, along with a number of other issues coming from the Geneva Conventions and then being funneled through or interpreted within, applied through whatever legislation we now get for military commissions. In fact, the White House bill states, this bill complies with the Geneva Conventions. Solved, finished. Of course, that doesn't make it so, but it does advantage the bill to the extent that it's a statement that Congress of the United States thinks that whatever is in here is consistent with the Geneva Conventions. Then when we end up back in court, which we certainly will if the White House bill or anything like it is adopted, the argument will be Congress decided to violate them and or this is Congress's interpretation of a treaty that, after all, it ratified. So, in particular, the issue arises as to one other part of the Geneva Conventions, which the Hamdan court did rule on. And this was the sort of narrow basis. It only had to get this far in order to decide the case in this regard. And as the court said in Hamdan, that is that Common Article 3 of the Conventions, a particular provision, applies to this conflict, and Common Article 3 requires, as Professor Siliman said, certain basic rights to be accorded to anyone, be they POWs or anyone else, unlawful combatants, what have you. The Supreme Court said in Hamdan that set of provisions applies, that set of minimum standards is applicable. The Congress says this statute complies with that requirement if the White House bill were to be adopted. But the White House bill, like any other bill, and like the situation that we saw with the first set of military commissions, the initial order from the White House, be it, the initial order from the White House in the first set of commissions that established the first set of commissions, and the new congressional legislation, if it's of this sort, don't and can't lay out all of the specifics of the terms and conditions of detention and trial of the accused. Can't do it. And so what happens is, of course, there are detailed rules and instructions promulgated under the authorizing document. Now it will be a congressional enactment. And so if those rules are to be created by Department of Defense, which is what will happen, to what extent depends on how detailed the legislation is and how much is left then to decide in rulemaking. But when those rules are made broadly or narrowly by Department of Defense, they may or may not be consistent in fact or in correct interpretation, whatever that may be, of the requirements of Common Article 3 of the Geneva Conventions. So even though the legislation says we comply, we have to see whether the rules and the actual in-practice application of legislation complies with Common Article 3. If it does not, if in practice the commissions don't, then we'll end up back in court. The arguments will be both that since in practice the commissions don't comply, they are not what was authorized under the legislation, since after all the legislation says this legislation makes for commissions that comply. And behind that will be, of course, a judicial interpretation of Common Article 3, which would have to be made in order to determine whether the practice does or doesn't comply with legislation. So all of these issues, and I've just only talked about the relevance of the Geneva Conventions within this debate, which is, as you know, just a small part of what was dealt with in the Hamdan decision. And within the Geneva Conventions, I've tried to point to just a couple of the issues that are likely to arise now in this second round. If the White House draft or something like it were adopted, these issues and many others, both arising from the Geneva Conventions and many other sources, will be raised. We will go through further litigation, and it may well be that we will be well past the presidential election before anything definitive happens. And I thought the other day that one interpretation of the perpetuation of this cycle between the president and the Congress and the courts is that justice delayed is the next administration's problem. So that would not necessarily be a inconceivable strategy for the White House to come forward with announcements like what we saw yesterday in the president's press conference. Quite impressive set of developments with regard to prosecutions before military commissions, really important defendants now being brought to book, but at the same time, not necessarily getting into what will be the less pretty and probably more controversial actual trials themselves. So that's a bit of, I think, where we stand now.
I want to thank the American Constitution Society and the Program in Public Law for sponsoring this and for inviting me. I want to thank all of you for coming today. Since January of 2002, when the first prisoners were brought to Guantanamo, the Bush administration has consistently claimed that the rule of law doesn't apply there. I argued the first case in federal district court on behalf of Guantanamo detainees in February of 2002, and the first case in the Federal Court of Appeals in the Ninth Circuit in January of 2002. And I was stunned then by the government's position. It was then, and it's continued to be, that those who are held in Guantanamo do not have access to any court in the United States to bring their claims. Additionally, the Bush administration has claimed that neither the Constitution, nor federal statutes, nor treaties are enforced to protect those in Guantanamo. In fact, when the first Guantanamo case came to the Supreme Court in 2004, there's a remarkable exchange between Justice Ginsburg and then Deputy Solicitor General Paul Clement. Justice Ginsburg asked him if even if the Guantanamo detainees claimed they were tortured, was it still the government's position that no court could hear their claims? Deputy Solicitor General Clement responded by saying, of course, the United States military would never torture any prisoners. By pure coincidence, it was the night of the oral arguments that the first reports of torture at Abu Ghraib were in the news. I don't think that that's why the court decided as it did, but in Rasool versus Bush in June of 2004, the Supreme Court held that federal district courts do have jurisdiction via writs of habeas corpus to claims by those who are in Guantanamo. And as already pointed out, in June of 2006, in Hamdan versus Rumsfeld, the Supreme Court held that the military commissions created by executive order violate the Uniform Code of Military Justice and Common Article 3 of the Geneva Conventions. I think these two decisions, Rasool versus Bush and Hamdan versus Rumsfeld, are enormously important. Above all, what they say is that the rule of law does apply, even in Guantanamo, even those who are allegedly part of Al-Qaeda. What I'd like to do is take a few minutes and give some thoughts about Hamdan versus Rumsfeld, and then talk about the legislation that was proposed by the Bush administration yesterday. I'd highlight three aspects of Hamdan versus Rumsfeld. First, as Professor Siliman said, the Supreme Court held that the Detainee Treatment Act does not apply retroactively. Let me explain what this means. As I mentioned a moment ago, in Rasool versus Bush, the Supreme Court held that those who are in Guantanamo can come to federal court by filing what's called a writ of habeas corpus. The Detainee Treatment Act, adopted in December of 2005, said that those who are held in Guantanamo cannot come to federal court via writ of habeas corpus. Their only chance of ever coming to federal court would to finish their proceedings in the military commissions and then seek review in the United States Court of Appeals for the District of Columbia Circuit. Review in the D.C. Circuit is not assured. Only if a death sentence imposed or a prison term of greater than 10 years imposed did the D.C. Circuit have to hear the case. The Supreme Court said that this provision of the Detainee Treatment Act applies only prospectively. That is, it doesn't apply to cases that were already pending in federal court at the time it was filed. Here's why this matters. There are dozens of cases brought on behalf of Guantanamo detainees that are pending in the federal courts. In fact, those cases were argued in the D.C. Circuit on September 8th of last year and are still awaiting decision. I'm representing one of the detainees, a man by the name of Siliman. He's been held since 2002 and has never been provided what we regard as due process. Had the Supreme Court said that the Detainee Treatment Act applies retroactively, all of these cases that have been pending for years in the federal courts would be thrown out. Now, because of the Supreme Court saying the law doesn't apply retroactively, those cases can continue and hopefully finally soon will come to decision. Second, the Supreme Court said that there was not adequate statutory authority for the military commissions created by the Bush executive order. The court pointed out that when military commissions were used during World War II, there was specific statutory authority. Here, the court said it didn't exist. One of the statutes that the Bush administration pointed to in the Supreme Court was the joint resolution authorizing military force. This was passed after September 11th. The Bush administration said this authorized military commissions. The Supreme Court said this wasn't specific statutory authority, certainly wasn't specific enough to contravene other provisions that are found in the law of war and the Uniform Code of Military Justice. Here's why this matters. Since September 11th, the Bush administration has repeatedly tried to argue that the joint resolution authorizing military force is permission for anything that it's wanted to do with regard to the war on terror. When it was revealed in December of 2005 that the National Security Agency was engaged in widespread warrantless electronic eavesdropping of conversations and email between those in the United States and foreign countries, and the issue was raised of, well, what's the authority? The Bush administration said, well, the joint resolution authorizing military force is permission for this. I think Hamdan versus Rumsfeld shows that the Supreme Court won't regard the joint resolution authorizing military force as a blank check for anything the administration wants to do. There has to be more specific statutory authority. And third, the Supreme Court said that the military commissions created by executive order violated the provisions of the Uniform Code of Military Justice and Common Article 3 of the Geneva Conventions. And the Supreme Court pointed to many aspects of these military commissions that violated this law. For example, it allowed individuals to be convicted without knowing the evidence against them. They could be excluded from the proceedings. In fact, even their lawyers could be excluded from the proceedings. The limits on what's admissible evidence, as found in the Uniform Code of Military Justice, weren't provided for within the Bush military commissions. And so after Hamdan versus Rumsfeld, the military commissions could not go forward unless they'd comply with the Uniform Code of Military Justice, unless they'd comply with Common Article 3 of the Geneva Conventions. Yesterday, President Bush held a press conference, and he offered proposals to try to create military commissions. My response to this is one of the most remarkably cynical things I've ever seen a president do, and that says something coming from this administration. Here's why I say that. This is already pointed out by the other speakers, Senators Warner, Graham, and McCain, not the liberals in the United States Senate, have introduced legislation to more closely follow the requirements of the Uniform Code of Military Justice. The Bush administration doesn't want to do that. So what they did was they transferred 14 prisoners from a CIA secret prison to Guantanamo and say, see, since we're putting these really dangerous people in Guantanamo, we can't follow the provisions of the Uniform Code of Military Justice. We've got to have more relaxed procedures that are followed here. Something else that's cynical about it is, though they say the legislation is just about military commissions, it has many provisions that aren't about military commissions at all. For example, as Scott pointed out, it liberalizes the definition of what's torture. It also says, and this is something that the other speakers didn't point out, that those who are held in Guantanamo cannot assert any claims under the Geneva Conventions or under international law. It also would make the Detainee Treatment Act retroactive so as to wipe out all of the cases that have been pending for years on behalf of the Guantanamo detainees. Additionally, as the other speakers have pointed out, the provisions of the Bush legislation would not comply with the basic requirements of American international law. For example, it would allow coerced statements to be used against the Guantanamo detainees. It would allow Guantanamo detainees to be excluded from proceedings for being disruptive or because of classified information without even having to give a summary of the information that was used against them that excised the sensitive material. And so it would not meet the requirements that the Supreme Court said are part of the Uniform Code of Military Justice, that are part of Common Article 3 of the Geneva Conventions. And I think it's important that the Bush administration finally admitted that there are these secret CIA prisons where renditions have been going on. They haven't been willing to admit that so far. There have been widespread reports of torture that are going on in these prisons. Now it's essential that the administration be called to answer questions. How many people are being held in these secret CIA prisons? How long have they been there? What are the conditions? Has torture gone on? Since September 11th of 2001, I've given countless speeches to various audiences about the Bush administration and its actions with regard to human rights and civil liberties. I've been surprised that often those who are most sympathetic to my position are those who have served in the military or have loved ones who are serving or have served in military. The reason is they constantly express concern. How can we expect that foreign nations follow international law when they're treating American prisoners if this country doesn't follow international law when it treats prisoners in Guantanamo, in secret CIA prisons? I think it's for this reason that it's so essential that the United States follow both the letter and the spirit of the Geneva Conventions when we treat those in Guantanamo. As the Supreme Court observed, this is both possible in a practical sense and able to protect national security. So here's what I think needs to happen. First, Congress should pass legislation for military commissions that meet all of the requirements of the Uniform Code of Military Justice and Common Article 3 of the Geneva Conventions. Second, I think it's essential that Congress excise from the Bush legislation all of the provisions that have nothing to do with military commissions, like changing the definition of torture, like making the Detainee Treatment Act apply retroactively, like keeping those in Guantanamo from asserting claims based on international law. And third, Congress should immediately begin a full investigation of the CIA prisons. I think this is what the rule of law requires. The United States should do no less than this.
Thank you all. I know some people need to leave, but we do have about 10 minutes left, so I'd like to open it up for questions now. Anyone have questions? I have right there.
Hi, Professor Morris touched on this, and while I was prior to the Hamdan decision, I decided to read through the Geneva Conventions to try to understand the Bush administration's argument that they don't apply to like members of the Taliban and Al Qaeda. And after reading through it, like sort of unfortunately from my view, I couldn't see how it did apply to like Al Qaeda. I can understand the Taliban, but I can't see Al Qaeda. I was just wondering what the reasoning is.
I agree with you about Al Qaeda.
Okay. Well, I was wondering, is like what is there? Is this, like what's the argument for how it could apply to Al Qaeda?
Yeah, pretty simple. Al Qaeda doesn't comply with the 4 conditions that would be required for POW status for combatants who are not members of the regular armed forces of a state. Al Qaeda members are not members of the regular armed forces of a state, nor do they comply with the 4 conditions that would allow that category to be considered POWs. So in a simplified version, that's why Al Qaeda really is quite differently situated from the Taliban, and probably is not entitled, at least in my view, to POW status if, under the facts that we know, whereas Taliban members probably, well, I believe are. That said, there's then the question of evidence. Are these indeed al-Qaeda members? Did they actually do the acts alleged? I mean, the amount of evidence that is available to demonstrate that the individuals being held were even combatants or what group they were a member of is quite a different matter. But as a matter of law, that's the breakdown.
Maybe you could address, though, I assume you do think that Common Article 3 of the Geneva Conventions applies to al-Qaeda, not the rest of the Geneva Conventions, but Common Article, at least that's what the Supreme Court said. Maybe you can say just a word about why is it that Common Article 3 applies to al-Qaeda?
Common Article 3, probably in the absence of a fifth Geneva Convention, is correctly interpreted, or at least wisely interpreted, to apply to al-Qaeda. It very much raises the question, is this or isn't this an armed conflict if what we're fighting with here is not a state, it's not a rebel group, it's not an insurgency, so do we even have an armed conflict? Because if we don't, then Common Article 3 doesn't apply. I mean, of course, I said at the beginning, and we're assuming that we do have a war here, we have an armed conflict. But the question whether Common Article 3 applies so presses that question. Common Article 3 says it applies to non-international armed conflicts. It would be hard to argue that this armed conflict, if it is one, is non-international. That said, I concur in the view that under the development of customary law, the requirements of Common Article 3 would require whether it were national or international. So yeah, if this is an armed conflict, then Common Article 3 probably applies to al-Qaeda. What about this Fifth Geneva Convention idea? My view is that what we see here is not appropriately covered by the existing law of war, as it is not appropriately covered by existing federal criminal law, or state law for that matter. It's not quite crime, it's not quite war. It's a thing that probably requires a tailored set of rules, domestically and internationally, that would be really suited. I mean, after all, in 1949, this wasn't what was being aimed at. What was being aimed at was for particular groups that are identified as being vulnerable and were identified as needing protection under law of war, thus the 4 Geneva Conventions. But we have another group now that is being dealt with in the course of combat, that is being captured, and that really isn't covered comfortably by the existing conventions or by existing domestic law, and probably requires a new body of international law, which in my view would be appropriately negotiated as a matter of treaty. That said, coming up with a treaty to that effect would be awfully difficult right now.
Let me add something on that last point. Although many suggest that because of certain ambiguities in translating the 49 conventions to whatever the environment we're in now, I believe, and Professor Bradley, you would know better than I do, but at least the U.S. position has been consistently that we choose not to negotiate a new treaty. We, as many of you may know, we have not ratified the additional protocols of 1977 because our position has been, as long as we can interpret the 49 conventions to our advantage, as was certainly done in the President's military order, then we're better off with the 49 conventions than trying to, by treaty, legislate a new provision which will probably be more restrictive than we would want it to be. So although I personally think that's a good idea, I think the United States would never subscribe to that. On the thing that Professor Morris referred to on the categories for POW status, before I came here and was still wearing the uniform in what I call the first Persian Gulf War, my war, we did run hundreds of what we call Article 5 tribunals to determine whether an individual was or was not entitled to POW status. I differ, I think, from Professor Morris in that when I look at the third category of Article 4A of the Geneva Convention, which is those members of an army not recognized by the detaining power, that I do look to incorporate the fourfold standard, and I think there's some support for that in the commentaries. And so I would agree with, I think, all of us that al-Qaeda is not entitled, as a matter of law, to POW status. I really believe that the decision should have been made to run screening tribunals on members of the Taliban. Matter of fact, it's true that the then Secretary of State, Colin Powell, who has some familiarity with military matters, having been the former chairman of the Joint Chiefs, actually went into the Oval Office, urged the president to follow our historical model to use these tribunals to determine POW status or not, and he lost the battle.
Well, this could be for any of you, I guess. We talked about the effect of any legislation, if there is any, and would have to be broader than would be strictly necessary to decide all the things you might need to decide to carry out the tribunals. So what's to prevent the president, even after he gets, say he gets a good bill from Congress that recognizes the Geneva Convention and codifies it in American law for whomever they decide should get it, what's to prevent him from willfully disregarding that in letting the agencies interpret it when they make more specific rules for how the tribunals should work and the evidence procedures they should use? What sort of accountability would there be for the president if it turned out that the instructions from the White House were interpret this any way you want, stretch it as much as you like, and create the policies that we have already from the new bill?
The same protections that there are whenever the president would violate the separation of powers and disregard law made properly by Congress, which is to say the question would be brought to the courts, who would decide, just as they have in Hamdan, that the president has acted without adequate compliance or recognition of the congressional powers under the Constitution.
So I saw you and you. So that's probably all we have time for. So first, second.
This is a question for the entire panel. In the course of the Hamdan decision, the Supreme Court cited to the 1977 additional protocols, which the United States has not adopted. To what extent does that fit into, and how would you analyze that in the broader context of the Supreme Court citing to international law? Because there is a big debate going on about that the last few years.
Let me take the first shot at that, Justin. Article 75 of the Additional Protocol 1 to the Geneva Convention, I think our own State Department has acknowledged to be customary international law. What that provision does is it sets forth the specific judicial guarantees that are referred to in the fourth part of Common Article 3. It defines and it says specifically, this is what these judicial guarantees are. So if it's customary international law, regardless of whether we've signed the protocol or not, we are nonetheless bound by it. That's basically what the court was saying. Now, granted, this is one aspect where basically you only had 4 votes on the court. You did not have this carryover adopting additional protocol, or Article 75 of Additional Protocol 1. But I think it's clear, and our own government acknowledges, that that helps define, give clarity to what a recognized court affording the judicial guarantees recognized by the civilized people of the world really means. So I think that's the test. Professor Chemerinsky and I have talked back and forth on how far this Common Article 3 applies. I'm not saying the Supreme Court did not say it applies outside military commissions. It definitely says it applies within military commissions. I think it's still an open question on whether it applies to other applications of presidential power.
Do you need us to get up there? No, we can just, okay. I want to answer the other part of your question, how this relates to other Supreme Court references to international law and foreign law in recent years. I think this is quite different. In a number of cases in recent years, the Supreme Court has pointed to foreign law as an additional reason for a conclusion it wanted to come to. So, for example, in a case called Atkins versus Virginia, the Supreme Court held that the death penalty for the mentally retarded was cruel and unusual punishment. The court said part of the standard for deciding what's cruel and unusual punishment involving standards of decency. The court said, well, one measure of it is that almost no other countries in the world would do this. In a case called Roper versus Simmons, the court held
that the death penalty for crimes committed by juveniles is cruel and unusual punishment. The court pointed out that as at that time, I think there were only 7 other countries in the world that allowed the death penalty for crimes committed by juveniles, and none were countries we'd want to be grouped together with when it comes to human rights matters. And again, it was pointing to this as evidence of evolving standards of decency. When the court in Lawrence versus Texas held that the right to privacy in the Constitution protects the right to engage in private, consensual, same-sex behavior, the court briefly pointed to what's going on in other countries. Now, none of these decisions were based on foreign law or foreign practice, all pointed it to as an additional factor. Nonetheless, this has produced a firestorm of protest, especially from the right, saying the United States shouldn't be paying any attention to foreign law practices when it comes to constitutional law. I think what Justice Stevens did in Hamdan in using international law was quite different than that, because he was saying that based on federal statutes that apply the law of war, therefore we have to follow Common Article 3 of the Geneva Conventions, and that they apply here directly. So it wasn't so much trying to use foreign law as an additional reason in interpreting the American Constitution. It was deciding under the treaties, the statutes of the United States, what are the requirements here.
I'm concerned about what the outcome of these tribunals, what impact that's going to have on the detainees. At the moment, we're holding over 100 people that the government says are not now a threat, and some people who we now believe never were a threat to the government, and yet we're still holding them in Guantanamo. What happens under these tribunals, under these new bills that are being introduced? We try these people and say they are found innocent. What happens?
You mentioned 2 different questions, I think. One is, what's the effect of a tribunal, of a military commission decision on a criminal case? Another is, what happens with people who have been determined to be non-dangerous and yet are still being held? I'll leave to one side, or at least give a vague answer to what happens with people who have been determined to be non-dangerous and are still being held, which is to say that A, we don't know, B, it has an awful lot to do with diplomatic negotiations with that individual's state of nationality for the most part. Coming to a clearer answer on the issue of what's the effect of military commission decisions, if we continue to have detainees at Guantanamo, and if, as would undoubtedly be the case, the person being tried before military commission is considered to be still dangerous, then if they're acquitted, they rejoin the regular detained population. If they're convicted, they go to a different punitive section of presumably Guantanamo. So it doesn't make them not a detainee if they're acquitted, but then again, all that means is that they're not guilty of a criminal offense, which is the same thing that's true for the other detainees. A difference, though, is that if a person is convicted at a military commission and sentenced to a period of years, then, or death penalty, then in the first case, sentenced to a period of years, and rather, obviously in the second case, they don't go home if and when the other detainees are released.
Distinguish between the power to detain someone captured on the battlefield, which Professor Morris has said, it's solid Geneva Convention law, with the prosecution, which requires the crafting of a criminal offense, which must be, under these types of tribunals, a violation of the law of war. I would suggest to you that we will see no more than 20 or 25 tribunals total. What the State Department has been trying to do for at least a year, probably closer to 2, is to depopulate Guantanamo Bay of those who will never face tribunals. The dilemma is that the government position in dealing with these other countries through the State Department is to say, we want you to take them back, but we also don't want them back on the streets so that they will come back to attack us. And in many instances, what those countries are saying back to us is, you never charged our citizen, therefore, under what grounds can we hold them? And that causes a dilemma. And then the United States tries to find a third country or a fourth country. Some situations are, we worry that that individual may be tortured. if we send them back to China or otherwise. But it is a political dilemma for this government in, as the president says, he wants to close Guantanamo Bay. It will take a very long time to do that, and that has nothing to do with military commissions.
If I can answer one quick,
okay,
let me
go
just
ahead.
one quick, because I know we're out of time. And I'll do this real fast because I know we're out of time. Undoubtedly, some who are in Guantanamo are very dangerous. They need to be detained. They've committed criminal acts. They should be convicted. But we also know that some who were brought to Guantanamo were taken there by mistake. The United States paid warlords in Afghanistan to identify terrorists, and some of them just identified their rivals to get rid of them. We know of mistakes that have been made, and people have been detained for long periods of time in error. That's why process and due process matters so much. There are now individuals who've been imprisoned, sometimes in cages, for almost 4 years without even being given the semblance of due process. That's why there's such urgency to this, and that's why this topic is so important.
One last point, very quickly, raised by your question and Professor Siliman's response, which is that if the individual being held in Guantanamo has been determined to no longer pose a threat and therefore not any longer need to be detained, but the reason that the individual can't be returned to his or her country is that there's a real prospect of torture, then the U.S. under asylum law presumably owes that individual asylum in the United States, oddly enough, but we haven't gone there.
Thank you all so much for coming. Again, if you have any questions about American Constitution Society, please find me, and please be sure to take your used